Hey, everybody. Hello, 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 hello. I'm going to wait a few more minutes while the folks get up in here. Let's see. Hey, Charlies. Whew. Hey, beloved. Beloved. Hey, Nats. Nibble. Hey, Charlie D. Oh, my God. I feel like I'm out of breath. Hey, Nick. Hey, Nosy Rosie. Hey, Nats. Oh, I said that already. Hey, Dinendra? Hold on a second. Hold on. There's a picture here. Hold on a second. All right. Hello, Charles. Hey, Serena. Hey, pretty queen. Y'all getting me tongue tied over here. Hey, J Town. Hello, Two Minds, One Mic. Hey, Miss Richard. Hey, Lady Red. Hey, Tall Glass. CBBJ, Candice. Hey, Classic Coco. Hey, Kiki. Hey, Kenzie. Hey, Bless. Hey, Blessed One. Hey, RD. Hey, Sheila Renee. Hey, Pink. Hey, John, my buddy. Hey, Ivory, because we got to have at least somebody from the other side. Hey, Pretty Brown Eyes. Hey, Rochelle, Kim, Brandy, Black Butterfly, Green Eggs No Ham. You digging me? Vi Baby, DD, Kiki, all of these, Lee, Woo Woo, Lisa Lou. Hey, Walanda. Hello, Demetrius. Hello, Tyler. Hey, M. Miller. Hey, Shay. Hey, Paula. Hey, Renee. Hey, Blue. Trying to get everybody in here. Hey, Alicia. Okay, let's see. Rashina. Natasha. BK. Let's see who else. Unpopular. I'm trying to get everybody, okay? Don't get mad because I'm calling everybody's name. He said, no, you know we attached to you like kids. Like your kids. Stop leaving us for a long time. Too long. I'm going to call CPS on you. Hey, loving. Hey, VK again. Hey, Tall Glass. Hey, let's see. Okay, let's see. Hey, Big Angie, not little one. Hey, Tipsy, anything new? Mika, Tipsy, anything new? CP Travel. Hey. Anything new, Tipsy? Tipsy is the man, y'all. Tipsy is the one who covers me when I can't get to the other person that gets me the paperwork. Tipsy is my paperwork dude. A few filing from yesterday? Okay. I think we got those already, right? We're going to go over those. Because we didn't do them yesterday. No. Sorry, y'all. I'm stuffing my face. Hold on. I'm stuffing my face. Because your girl got to eat and got to put something in her stomach. I know I should have did that early, right? Cantavius, hello. All right, y'all. A couple of you guys asked me for Boosie's update. I have that for you guys. I was hoping Dom would come in here and tell me if he went, but I don't know, y'all. Hey, Lynette. Mercy. Hello, y'all. Makita, TT, Grateful 1509. Hey, Elevate. Hey, 147, Love Vintage. Hey, Miss W 1985. Salad. What else did I have? I had chicken, grilled chicken from the grill. I had cabbage. What else? I went to my barber. My barber fed me. Oh, you say you look better. I feel better. I went my barber cook every time I go to my barber, he feeds me. Barber always feeds me. Shout out to my barber, John. He feeds me, y'all. Yeah, just get him up in here talking about, oh. She is like, I'm gonna just put up what she just said. Look at this. Look at her. Look how she acting, y'all. Look. You see what she said? You see what she said? Acting up. Mm. Just so bad. Just so bad. And Miller, you just you're not gonna be managed today, are you? Please don't be managed. Yeah, Blue, my barber feed me. Yes, Blue, yes, my barber feed me. Every time. I can always get a meal from my barber. All right, let's go. We got some work to do. Shout out to two mic. I mean, two mouth, one mic. Right? Is it two mouth? One mic. Shout out to her because she did some work for me, as in she got some oh, she did some time stamping for me because some things I wanted to show you guys in regarding to Miss Love Lion, y'all. Ooh, chow. Ooh, Jesus. We're going to talk about that. We're going to talk about that. We're going to talk about what's going to happen on Monday. We got a lot to talk about. And you know, I hate two minds, one mic. I'm sorry. Did I say two mouth? Two mind, one mic. I'm sorry I'm messing up your name. I'm sorry for messing up your name. Oh my God. She's gonna get me, y'all. She's gonna get me. Oh my Lord. Oh, good. She's working, y'all. She's working. Okay, JC. I'll just say JC because this two mics, two nose, two ears stuff. She driving me nuts. But she's working. She's not paying attention to me. Oh, you did? You did on Twitter? Okay. All right. She tagged me on something on Twitter. Okay. All right. Let's get to Boosie. Boosie's news is not going to be that long. It's going to be real short because I don't know if Dom actually went. So we don't have much to talk about with that. But what I do know that they did do a Hold on a second. Let me go ahead on and do this for you. I'm pulling up my laptop. Blue said, love to Rachel, best friend. Huh? Love, DA love attorney to Rachel, best friend? Who? Oh, y'all, Nona bless somebody, bless 5 people with the membership. Let me know which one you guys got the membership. Let me know. Please let her know. Say thank you to her. Who has the membership? Who got the membership? Thank you, Nona. Tall Glasses got it. I see who else got the membership. YouTube don't automatically do it. Oh, you trying to be funny? Okay. Oh, they talking bad about her? Ooh. I wish I had a membership. I love this channel. You have a membership, Nick. What are you doing? You got a membership right there. Did somebody just give you a membership? I see your membership. Hey, Gemini, you feeling better? Hey, Miss Richard. Okay, y'all ready? You guys ready? Thank you, Princess. Price. I don't know, y'all. I don't know how to read no more. I give up. I just give up, y'all. I just give up. Sylvia, who do you want to play you when the Netflix Yvonne? Let me tell you. We were doing I want to tell y'all something. People listen, y'all. Folks are trying to come at me saying that I'm copying off of the reenactment of transcript, but let me show y'all something. Hold on. I gotta hold on a second. I want to show you something. Hold on. Okay, I want to show y'all something. This here was in 2022. And these folks talking about I copied off of them with the reenactment and all that. But look, y'all, look at this. Look at this article. Y'all, you see this article is dated back when by Messner of Chicago Tribune, right? And guess what they called me? Where is it? Let me show y'all. What does it say? What does it say? It says, as the trial unfolded in New York last year, one blogger who posted under the name of Infamous Sylvia used actors, what? Used actors to read aloud the trial transcript, creating what she billed a role reenactment. Okay? All those freaking people who kept claiming that I stole the idea of reenactment. Hello? Y'all wasn't even around when I did that. Y'all see that? Thank you. You see that, y'all? They try to come at me because the other day we did that reenactment, y'all, where y'all play your part. Shout out to my people. Shout out to my people. X901 Don Diva. For real. They come out trying to come at me. Come at me. They come sending messages, and I'm like, what? What? Look at Nona. Nona did another gifting, y'all. Shout out to Nona. Y'all, they're gonna say I copied off of them with the reenactment. I've been doing this since 2022. This is what, 25. I've been doing this a long time. Shout out to my actors that did it this time, but I've been doing this. You got a membership? Congratulations. You got a membership. Thank you, Nona. That's weird to even think it was a stolen idea. People reenact stuff all the time. Thank you, Popular. I just wanted to show them it's written, it's documented that I've been doing this. It's documented right there as the trial unfolded in New York last fall. One blogger who posts under the name of Infamous Sylvia used actors to read out loud from the trial transcript, creating what she billed as role reenactment. All right. People get mad because I be trying to, tell them to, hey, don't come at me. All right. Sorry. I'm not. Okay, I won't let them steal my joy. It's just that, they just keep coming at me, coming every time, y'all. All right, let's go ahead on and get Boosie thing. That was just my little commercial break because I was trying to let this computer update so it can I was letting it update so I can get the stuff sent over to my computer. Okay, let's send this to my Why is not airdropping, y'all? Why my thing not airdropping? Oh, there it is. There it is. Let me airdrop the other. It airdropped twice. Let me get the other one here. Okay, let's get this one. I'll close this one out. Let's airdrop this one. Let's airdrop this one too. Airdrop. Okay, come on. Hold on, y'all. Hey, crazy girl's ringing the doorbell. Hold on. Yeah, she ringing the doorbell. Hold on. Thank you. All right, y'all. Sorry about that. I had to open up the door for Dallas. Okay. Here we go. This is the update for Boosie. What the? All right. All right. This is what it says here for the pre-trial release. Here we go. This is Boosie's pre-trial release. You guys can see this? Can y'all see that? Try to make it bigger. Can y'all see that? Is that big enough? Can y'all guys see this? Can you guys see that? Can you read it? You guys see that? I was trying to bring it up. Yeah, you see? Okay. All right. Here it is. It says, case number 324-CR-01508 CAB. Remember what I told you what CAB stand for? That's the initials for the judge. Okay. It says document number 13 filed on August 2nd, 2024. 24. Page ID 26 and page of 1 of page 2. It says United States versus Torrance Ivy Hatch. And it says, I don't know what T/N mean. I don't know. But, it's gone. Yeah, yesterday. It was bad. I was bad yesterday. Remember I told you I was bad? I ate the cake and all that stuff. All right, let's go ahead on. It says here, it is ordered that defendant release is subject to these conditions. Mandatory condition. These are mandatory one, and then it has the stricken, unless it's stricken. Then these are standard one down here, and then this is the additional condition right here. Defendant must execute an appearance bond in the amount of $100,000 that is unsecured. And then it says defendant's signature, own signature. Anybody knows what that means? Unsecured. Do he have to pay it, or there's another paperwork right here? Oh, he's not restricted to travel anywhere. I mean, he's not restricted. He's not restricted because he doesn't live in that county. Down. Okay. I was wondering if you left already. So he's on bond again. You said you think it's 100%? He has to pay the 100%? Oh, man. Unsecured defendant. What does that? Execute an appearance bond in amount of 100,000, and that is unsecured. What is this? What can someone tell me with the gift setting? Should it be O, or should it O this side? I don't know what to mean. I don't know. No bond, cash. RD, you said, yep, no bond, cash. Unsecured. Okay, I'm confused. Yeah, somebody could explain this to me, because I don't know what this terminology and stuff like. Well, there's another paperwork. Let's go look at the other paperwork and see what happened. Let's go look at the other one. Because guys, I am not an attorney, so I don't know what the heck these things is. Okay, this is the bond condition. Okay, now let's see. Let's show you this one. A cash money bond. Oh, okay. This is the other one. It says new bond condition right here. It says here. To the United States Marshal and Warden, Metropolitan Correction Center, please be advised under date of August 2nd, 2024. Defendant appeared in court, fingerprint and release. Or other new indictment filed against the defendant prior case numbers 23 CR 1205 CAB. No booking. No new booking. No required defendant release on signature. Oh, he got a signature bond, y'all. He got a signature bond. Okay. Unsecured means that not back with any equity. He got a signature bond. Got a signature. Release on signature bond. He can use a bond man for 10%. No, he got a signature bond. There's no money. If he fails to pay, he got paid that 100,000. He was released without cash. Thank you, Gemini. Thank you. Okay, y'all. I got it now. Thank you, guys. I was confused. It was 100,000, and it says, is he back on monitor? It doesn't say anything about being on monitor now. Because remember, they removed the monitor last time. So, thank you, Alethea, for becoming a new member. And thank you, Nona, for gifting all those wonderful people with the membership. She gave out 10 membership. Shout out to Nona. How he get released without cash? Well, I don't know. I don't know, Mickey. I don't know. IB pays a whole 100,000 and don't show up, he loses all of it, basically. Okay, so he didn't have to pay it, because right there it says no new indictment filed against the defendant prior case number 23 CR 1201 CAB. No new booking required. Defendant release on signature bond. This is for Boosie. This is for Boosie. You've never heard of this ever? Well, This is the first time, Mickey. Because remember, he paid bond before. I don't think they ever gave him back the money for the last bond. They might still have it. And the feds, you don't pay a cash bond. That Antonio just gave y'all the information, y'all. Take heed. Antonio just gave y'all some 411. In the feds, you don't pay a cash bond. Guys, what you airdropping? Oh my gosh. Oh, Lethea said she just cancel her Temu. You better stop buying that stuff from Temu. Temu gonna get y'all in trouble. Okay. Gemini, he paid last time. He paid a bond last time. Boosie got a bond. This is Boosie. He got a re-indictment, y'all. The rapper. It depends. Not true. Boosie always in trouble, Mickey says. He got that money back because the case was dismissed. So he did get the money back. Okay. Well, he didn't have to pay this time. He says Boosie's going to beat this case because of his attorney. Okay. All right. So that's it for Boosie's update. It's all just targeting. So that's all of it for Boosie. Let me see somebody. Okay. I agree, but Black Butterfly, I agree. RD says definitely targeting. Was in California. Yep. Yep. He got reindicted on the same charge, but the only thing is they add one charge of being an addict. Really, y'all? Really? How you gonna prove him being an addict? Because he didn't have to go to rehab. So how is he an addict? Don't cancel my knees and back from Temu. You know what, Shady. But so that's it right there on that. So let's go ahead on and move on to anybody have any question? Anybody have any question in regard to what we have here with Boosie? Because since Dom has not contacted me and tell me whether or not he was there, I don't think he was there. But remember, I was in court, so he might have been there and he did not reach me, but I don't think so because I would have had calls from him. So I don't know, RD. I don't know why they don't dislike that man. Penny is going, hey, Pastor. Try to take any superstar down in Atlanta. Yeah, we have 6 o'clock. I have a mods meeting with my mods. So if we don't get done with our update, I'll come back and give it to you guys because I got some stuff I need to play for you guys. So let's go ahead on Remember yesterday, right? I'm gonna play yesterday's live, some parts of it. But remember yesterday, one of the things that Love said, let's go listen to the end of yesterday's. How's my daughter doing? She's doing fine. Dal, someone's asking how you doing. She's good, tall, too tall. Remember yesterday, we hold on a second. Yesterday we went, hold on a second. August 2nd, we need to do the second half, right? Okay. Hold on a second. Okay, we're gonna start off. Okay, here we go. Hold on a second. Okay, hold on. We're gonna put it on now because we got something I want to share with you guys. Hold on a second. Let me put it up here. Hey, everybody that's coming in, please don't forget to hit the like button. Okay.
This will be brief, but Your Honor, important to us and to the court. On February 7th, 2023, on April 18th, 2023, September 6th, 2023, January 13th, 2023, and one more, and then, which I don't know the date, July 29th, 2024, Mr. Williams has put in Brady motions.
Okay.
And the state has not complied with Brady. They comply at times. I'd like a date certain, like today, that any Brady evidence that is still outstanding, that it has to be to us by Monday or whenever you think, Wednesday, whenever, because Brady is, so serious, because then we go out and investigate, but the witness is already on the stand.
Right.
So I've, I know I don't have to put in writing. It's not good faith or bad faith. It's a prosecution team. But if the court can just set a deadline, and then obviously it's ongoing because new information may come forward. That's my only issue.
Okay. Is there anything that you, know of that you don't currently have?
No, because then I'm not so sure it'd be Brady.
It wouldn't be, but people refer to stuff as Brady, even though it comes out and you have it for the trial.
But anything, Mr. Zachary is a perfect example. I have no evidence of this. But if he's coming to testify, the state has alleged that he's a co-conspirator, unindicted. There has to be some sort of agreement. I mean, there just has to.
I'm sorry, some sort of what?
There has to be an agreement.
An agreement. Oh, okay. Well, a lot of times there's not any agreement. Okay. There might be.
But
I would hope that the state knows that if you have an agreement with.
Y'all, I need y'all to do me a favor. I need y'all to keep an eye on her, on Love. Okay.
You
Why does it keep doing that, y'all? It's keep going to, what are they? Somebody's messing with my stuff? Look at this. It keep making it. Hold on. Why is it keep going mute? See, look at it. It's going mute. Look. Are they messing with my stuff? Let me stop. Hold on, y'all. Let's go ahead and keep muting it. Hold on.
I mean, more lenient treatment, any kind of an agreement that you need to reveal it. You know that, and you will do that. And you will do it as soon as you know it. If one does not currently exist, but one develops next Tuesday, then tell the defense next Tuesday.
Okay.
We will.
Okay. And as to any Brady material, you know and understand your obligation is to everything you know right now that is material, potentially exculpatory, anything that could be covered under Brady, you need to provide to the defense if you have not already done so. And I'll let you make a statement if you would like to after I finish talking. And the Brady obligation is continuing. So if y'all are still doing any kind of investigation, you come up with anything that is Brady material, then you also need to get that immediately to the defense.
Yes, we understand that.
Okay.
obligation, And
All
we
right.
will continue to comply, and we will converse. And if there's anything that either team member is aware of that we need to provide, we'll provide.
Okay. Thank you.
Thank you, Your Honor. Thank you.
All right. See y'all at 8:45 on Monday, 9 on Monday. Yes, Mr. Sharp. Let's say 9. Y'all did such a good job today. I'm going to give y'all 15 extra minutes to
like a
sleep.
teacher.
9 o'clock on Monday.
Like, y'all was
Your
so
Honor, I just wanted to bring it to the court's attention
Uh-oh,
that I know that Mr. Weinstein has an outstanding motion
Uh-oh.
that he renewed maybe 48 hours ago.
Which was,
You might talk about my mistrial?
Yes.
oh, no, I know. He has a supplement to that. And I thought I said this morning, that's what I'm going to be working on this weekend.
And I have some bad news for you.
What's that? You
As
have
we
more
head
to
into the
add?
week- Yes, Mr. Weinstein's a faster writer than I am, but
He is a good writer.
he is.
Very kind of you.
Welcome.
So I recently filed while we were in court, a motion for a fair trial.
Oh, look at
seeking
look.
remedies. Oh, and I will email, it was just filed. And I
You see her hand to her face, y'all? You see her hand to her face? You guys see that? Look, you see her hand to her face? Mickey, stop laughing. Don't laugh. Don't you guys laugh. Do not laugh, y'all. Look at y'all. Look at y'all. Y'all so messy. Stop it. Do not laugh. Stop it. Guys, you do not laugh at somebody's misfortune right now. Don't do that. Just stop. Stop it. Y'all being mean. Don't be mean. Auntie M, please tell them stop being mean. Just stop. Look at this. Look at her face. Look.
will email it over. Mr. Steele brought up the desire to have an evidentiary hearing on these matters. I know that
You okay, I'm not gonna laugh, but don't she remind you of this lady right here? Hold on, y'all. I'm not trying to be funny. I'm not trying to be funny, but don't she remind you of this lady right here? I got something to show y'all. Hold on. I want to show y'all something. Hold on. Yeah, I'm not trying to be funny, but I wanted to show you something. I want to show you something. Hold on. I'm just gonna try to be messy for a hot second. I just want to show you something. Hold on. Don't she remind you of this lady right here, y'all? Hold on. Does she remind you of this lady right here? What? Watch.
As charged in count 1. We further find true the allegations that Diana Jean Lovejoy was vicariously armed with a firearm within the meaning of Penal Code Section 12022, paren A, paren 1, dated 11/13/17, signed foreperson. Same title, same cause.
Look.
Verdict. We, the jury, in the above entitled cause, find the defendant, Diana Jean Lovejoy, guilty of the crime of attempted murder of Greg Mulvihill in violation of Penal Code Section 664/187, paren A, paren 1, as charged on count 2. We further find true the allegation that Diana Jean Lovejoy acted willfully, deliberately, and with premeditation within the meaning of Penal Code Section 189. We further find true the allegation that Diana Jean Lovejoy was vicariously armed with a firearm within the meaning of Penal Code Section 12022, paren A, paren 1, dated 11/13/17, signed foreperson. In the Superior Court of the State of California, in and for the County of San Diego, the people of the State of California, plaintiff versus Weldon K. McDavid, defendant. Case number SCN 363-925, DA number OCD 980. Verdict. We, the jury, in the above entitled cause, find the defendant, Weldon K. McDavid, guilty of the crime of conspiracy to commit murder.
I know I'm messy. I'm so messy. I'm sorry. I told you to stop. I'm sorry. I'm sorry. Okay, I'm sorry. Please forgive me. I'm sorry. I'm sorry. Look.
Which matters.
The ex parte communications and the impropriety.
Yeah, like wanting to cross-examine the.
I like that lady.
Oh, yes,
Calling
wanting
John
to
Melnick.
put Mr. Melnick's testimony, and yes, I had said that you could give me a proffer, and if you're ready to do that, we can do that.
Well,
Look, you see.
Y'all don't want to do just a proffer.
Mr. Steele was the, spoke to Mr. Melnick, but yeah.
Okay. All right. So with regard to the motion, Mr. Shart, that you filed within the last few hours, if you could email that to Ms. Persifield, I'll take a look at that over the weekend as well. Mr. Steele, if you want to be heard on I'm glad. Thanks for the reminder to circle back on that. I had said, talk to Mr. Melnick and you can put a proffer on the record. So if you're ready to do that, we can do that now.
I need more time because I did speak with Mr. Melnick. I told him what your Honorable Court said. He stated that it was very nice. He stated I does not give you permission.
I was in the hallway. I saw Melnick out there in the hallway, y'all. Out there in the hallway.
That's what he told me. So I can't make a
in the
proffer
hallway.
because I don't have the information. I have him under subpoena, like I told
Okay.
you. I was going
What do you have him under subpoena for? When?
2-hour call. 2-hour call.
Okay.
Melnick was in the
Well-
hallway. Melnick.
Can you proffer to me? I know you can't say, here's what he would say, but how about tell me why it is that you think this is something relevant to this trial at this stage, considering that Judge Glanville has already been recused. And maybe y'all want me to, I have not finished reading all of the material and all of the case law. So I don't know what my decision is going to be on the supplemented motion for mistrial that Mr. Weinstein filed on behalf of Mr. Kendrick. Do y'all want, I mean, I will rule this weekend. Do you want to wait and see what that is? Or do you want to just tell me why is it that anything Mr. Melnick might have to say in defense of himself matters for the trial? It might matter for everybody's, you know, what they feel about their professional reputation. I get that. But for this trial, why does that matter?
So under CAR, C-A-R-R versus state, it's a 19, I think, I don't know, 97 case, 98. It was the case that gentleman owned Heights Nursery, I think, the house burned down.
Yeah.
There's great language in there about prosecutorial duties.
All right.
And
Heights
and
hasn't
it talks
been
about
around
the
in a long time.
prosecutors need to, they carry the burden. They can charge people, they can ruin people's lives just by the charge. And they have a duty to the public to be open and candid.
Sure.
So, and all lawyers do, but especially prosecutors. And Mr. Melnick, I know this because he did say this, and that's why he wants to address you, because he was not mad at me. He said he needs to have it on the record himself, because he said that what the state was saying is not accurate.
Okay.
And I think that that goes into your analysis of why there was a meeting in the first place. I don't think that it was appropriate, like, and I'm not picking anybody, but like the Honorable Judge Krause said, if I was going to ask this Honorable Court for an ex-parte meeting, I believe that the way I always have it is there's a buffer. You have somebody say, what is it about?
Yeah.
I tell you, and I have to be candid. And if I'm not, in hindsight, you would probably, I assume, or any court would tell me, you had no right to do that because you got it with false pretenses.
Okay.
Mr. Melnick is going to say that what Adrian Love said to the judge is just patently not true. Via emails, her description of the emails is untrue. And there's no way to say that's inadvertent, because she said that on Friday the 7th versus Monday the 10th, she kept talking about these emails and she changes her statement. So anyway, I believe that it's.
All right, the best evidence of that would be, I'm sorry, I didn't mean to interrupt you, but just somebody getting the emails.
We're coming
I
in
put it
Wednesday.
in my motion that I filed when I found out this honorable court was the court. And I forget what I titled, I can find out for you, but
Okay, I'll go back and look at those.
it was a motion, it had two parts to it. And it said, I really don't want, and I told you, I don't want a mistrial. I just want to make it right. And I want the record to be good. So anyway, Mr. Melnick is going to take to task, and you'd make a credibility determination, Adrian Love, John Melnick's statements. He also adds that he states that he and his client, and he did not tell me, I said I don't want to know because it's attorney-client privilege, but he's going to work on it. He said, I assume that's a waiver. I'm assuming that with his client. He's saying that what Ms. Hilton said to the court and by both courts is not accurate also.
All right.
Then I have information that there's off, so it's not in the transcript. So Mr. Weaver is either not there or definitely not recording it, that Mr. Copeland did talk about the killing of Donovan Thomas, that is not on the transcript. And that would be either Brady, if it's an inconsistency.
So wait, so that I understand what you mean. You are saying that you have reason to believe that in the June 10th ex parte meeting, once Mr. Copeland was a part of that he talked about the killing of Nutt at a time when Judge Glanville was in the room? Because there were definitely two different portions where at one point he and Miss Bumpus talked privately, which obviously nobody recorded because the court at least the record reflects the court reporter and the court and whomever left the chambers so that they could talk privately. So it's entirely possible he talked to her about that. That wouldn't be on the record, and it shouldn't be on the record. Nobody else heard it. And then there was another portion where I believe the court left so that I don't know if it was you, Miss Hilton, or I think Miss Hilton, Miss Bumpus, and Mr. Copeland could talk together.
That's what I'm talking about. So it's not privileged.
Okay,
We told
all right.
that there was substantive conversation about the killing of Mr. Copeland.
Okay, so
And Ms. Hilton,
hang on. I'm jotting some notes for myself. Give me just a second. All right, and you have reason to believe that whatever Mr. Copeland said at that point in time in front of the prosecution is something that is Brady material.
impeachment. is what I was-
Okay, impeachment.
so-
Okay,
Which is.
and therefore Brady. Okay,
So that's why I wanted to put.
all right, thank you.
And call the prosecutors. Now, they may say that didn't happen, and I assume that's what they're going to say because they would have a Brady obligation to run out and say, June, this happened, this man said this, but they didn't say that with anything, so I don't trust that the Brady was being complied. That's why I asked you again today, please, can you put some teeth into Brady? Because Mr. Copeland did say on the record, I'm a liar. That is Brady.
Uh-huh.
That's like the greatest Brady.
Well, you got that,
I
so
got it now, but I got that because.
I know, but you have it now, so it's not Brady, just like you just said.
But my point is, it was hidden on the 10th. How about that? By Judge Glanville and the prosecutor. They knew about it because they were in the room when that was discussed. That's objectively true. So anyway, I'm just telling the court, I was not there. I don't want to make specious allegations against anyone. That's why I want to get it right. And that's why I asked you to have an evidentiary hearing.
Okay.
But I believe that there's Brady evidence. I have a good faith belief. I'm telling you everything I know. I'm told that it's not privileged that Miss Bumpus, Miss Hilton, Mr. Copeland spoke, and it's not in the transcript. And Mr. Copeland was talking about his information on the killing of Donovan Thomas. Because you have to remember, in the statements, he has himself not involved.
Mm-hmm.
He has himself learning about from another person.
Right.
And my understanding is that is not what he said. That's inconsistent on June 10th. And I did not get that from Ms. Hilton. If that's wrong, but I can't ignore what I'm being told.
Okay, well, that's new information for this court, so.
That's what I wanted to
She said new information for this.
call the witnesses because,
All right, well, you didn't tell me that before.
well, I didn't mean not to tell you.
Look at their faces. Look at
I
the.
was trying to be open, but that's the reason I wanted to call witnesses.
Okay, I mean, that's, okay.
Look at the state table, y'all.
Additionally, Your Honor,
Yes.
at some point, I believe, you're going to have to make a finding of fact on the propriety of these ex parte communications.
Oh, I know, that's a
And-
part of Mr.
Right.
Weinstein's motion for mistrial, yeah.
And I don't want to be a witness. I mean, I could say that there was absolutely no reason for it, and there was no cause for the state to even have these concerns. But Mr. Melnick can explain, if he was conspiring with me and Mr. Steele to obstruct justice, I doubt he'd want to come in here and talk about it, but the state can ask him about it and get to the bottom of it. But I don't think that's what the testimony is going to be.
Okay,
And I think that's important for the court to know.
Okay, well, I don't know that whether it's true or not is what matters. It's what it looked like at the time to the state to give them a reason to say to Judge Glanville, we have some concerns. We might like to talk to you about it. Just heads up, we're going to do some research. We'll get back to you. And by the way, y'all, I know that everybody, whenever we were here last, was that yesterday or the day before? Wednesday? So Tuesday, I gave y'all the transcript from the 7th. And Wednesday, a couple of people made some statements about, oh my gosh, now lo and behold, we find out there's been yet another ex parte we never ever knew about. And actually, when you go back to the transcript of the June 7th, 2024 court proceedings, on page 95, on the record, before court adjourns for the day, is when the prosecution says, hey, by the way, we might need an ex parte, or we need an ex parte. And then it is definitely still on the record in court where y'all all heard not the content of the ex parte, but that the state wanted an ex parte, because people from the defense say other things on the record after that. So in open court, y'all were notified that they wanted one. So, I mean, it's not quite the salacious revelation that y'all made it out to be.
Can I respond to that?
Yes.
So as in the King case that the state is relying on, the state has to make a showing of necessity for public, the necessity for the public interest for the for immunity to be granted by the court.
Okay.
And I was under the impression, I think a very reasonable deduction was that they were simply going back there. And I agree, they did announce an open court and we didn't know the substance, but I think a fair, reasonable deduction would be that they were going back there to present the basis for granting
Okay.
immunity. Little did we know that they had already done that and they were going back there to have that other
Something else.
conversation. So
Okay.
that's
Okay. Yeah, I mean, I know y'all didn't know the substance of it, but
And wrapping back around to that.
yeah.
I don't know if there was, but I'm assuming that under the King case, since it wasn't, I guess, that afternoon of the 7th, maybe it was prior to that, maybe it was in the morning, maybe it was the afternoon of the 6th, but at some point under King, there would have been some type of an ex parte meeting where the state presented the reason that they needed that immunity. I don't know if that was done on the record, if there was a transcript of that, but if there was, we have not received that either.
Well, there better not be anything else that
Well, how did they
occurred
get?
as a meeting, because I told everybody on Tuesday, stand up and tell me anything there is. Did y'all do anything beyond the motion to get the immunity order for Mr. Copeland?
Uh-oh.
No.
Okay,
So we submitted a motion.
right. And they have a copy of that, and that's,
Right.
all right,
Right.
Okay.
That was,
okay.
and Judge, I'll also state that at the time, I'm not certain why it would be believed that we were trying to get the warrant or the immunity agreement, because Mr. Copeland was under arrest at the time that we stood up and made that announcement in court on the 7th. I think he had already been arrested, I
Well,
think.
you could be arrested and not have immunity for your testimony.
The judge had already told him he had immunity on the record.
Okay, well, I don't know. I mean, they're
Okay,
probably just trying to remember it themselves too, but
Okay, I'm trying. Y'all, this is the thing I don't understand. Did y'all understand what she just said? Did y'all understand? Guys, did y'all understand what she just said? I'm confused. She said that they had immunity. I gotta play that again. Did you guys? I'm confused. You confused too? There had to have been another meeting, y'all. There was, in order for you to do the motion, there had to have been a meeting for you to. She said she just did the motion without speaking to the judge. So I'm confused, y'all. I'm really confused. I'm confused. Okay, I'm gonna play it again. Maybe somebody could explain it to me if you guys understand this. You don't totally I'm confused. Okay, let me just play this part again because I don't get what they're saying, what she said, because she told the judge that they didn't have any other meeting, right? Just the motion she put in the motion. Hold on.
Time to the state to give them a reason to say to Judge Glanville, we have some concerns. We might like to talk to you about it. Just heads up, we're going to do some research. We'll get back to you. And by the way, y'all, I know that everybody, whenever we were here last, was that yesterday or the day before? Wednesday. So Tuesday, I gave y'all the transcript from the 7th. And Wednesday, a couple of people made some statements about, oh my gosh, now lo and behold, we find out there's been yet another ex parte we never ever knew about. And actually, when you go back to the transcript of the June 7th, 2024 court proceedings, on page 95, on the record, before court adjourns for the day, is when the prosecution says, hey, by the way, we might need an ex parte, or we need an ex parte. And then it is definitely still on the record in court where y'all all heard not the content of the ex parte, but that the state wanted an ex parte because people from the defense say other things on the record after that. So in open court, y'all were notified that they wanted one. So, I mean, it's not quite the salacious revelation that y'all made it out to be.
Can I respond to that?
Yes.
So as in the King case that the state is relying on, the state has to make a showing of necessity for public, the necessity for the public interest for immunity to be granted by the court.
Okay.
And I was under the impression, I think a very reasonable deduction was that they were simply going back there. And I agree, they did announce an open court and we didn't know the substance, but I think a fair, reasonable deduction would be that they were going back there to present the basis for granting immunity. Little did we know that they had already done that and they were going back there to have that other conversation. So that's
okay. Yeah, I mean, I know y'all didn't know the substance of it, but
And wrapping back around to that.
yeah.
I don't know if there was, but I'm assuming that under the King case, since it wasn't, I guess, that afternoon of the 7th, maybe it was prior to that, maybe it was in the morning, maybe it was the afternoon of the 6th, but at some point under King, there would have been some type of an ex parte meeting where the state presented the reason that they needed that immunity. I don't know if that was done on the record, if there was a transcript of that, but if there was, we have not received that either.
Well, there better not be anything else that occurred as a meeting, because I told everybody.
Wait. It's what Weinstein just said that she was answering to, y'all. What Weinstein just said. He said, well, we're just thinking because it had to been a meeting prior to them getting immunity, right? And because they wasn't paying attention. We saw they weren't paying attention, but we did hear her ask the judge for a meeting. She did ask, but there was a meeting like between him signing that immunity, which should have been Thursday night. This might have been another meeting. There might have been another meeting. Oh, wow. Okay. So this is what, okay, hold on. I think Weinstein and them know more than what they're acting like they know. There's something that they know about.
That they wanted one. So, I mean, it's not quite the salacious revelation that y'all made it out to be.
Can I respond to that?
Yes.
So as in the King case that the state is relying on, the state has to make a showing of necessity for public, the necessity for the public interest for the for immunity to be granted by the court.
Okay.
And I was under the impression, I think a very reasonable deduction was that they were simply going back there. And I agree, they did announce an open court and we didn't know the substance, but I think a fair, reasonable deduction would be that they were going back there to present the basis for granting
Okay.
immunity. Little did we know that they had already done that and they were going back there to have that other
Something else.
conversation. So
Okay.
Okay. So the request for the immunity came on, wait. The immunity came on supposedly after Melnick talked to them that Thursday night. Because remember, Thursday night is when Melnick said he actually talked to them. And that's when the email came out and all that, right? And the ex-parte was signed that morning, early in the morning. So between Thursday night and Friday morning, there was some sort of communication. Or it could have been a couple of days before. We don't know. No, it had to have been. Because if Melnick came in and told him, because the reason why, because Melnick, I'm so confused. Okay, I'm trying to put it together, y'all, and I'm still not making sense. Hold on.
that's
Okay. Yeah, I mean, I know y'all didn't know the substance of it, but
And wrapping back around to that.
yeah.
I don't know if there was, but I'm assuming that under the King case, since it wasn't, I guess, that afternoon of the 7th.
Valent, Woody didn't have to sign it. There was an order done by the judge. He didn't have to sign. It was like a forced immunity. He didn't have to sign it.
Maybe it was prior to that, maybe it was in the morning, maybe it was the afternoon of the 6th, but at some point under King, there would have been some.
But he said maybe it was in the morning, maybe before, sometime after the 6th. Let's see, hold on. I know, I'm sorry. You know me, I like to play things over and over to try to figure out. Yeah, Woody was there, guys. Somebody just sent me a text message. Yeah, Woody was there that throughout the whole week. We just never seen him because they were talking to him. He was there then beginning of the week because he was supposed to come in on Tuesday. He was there Tuesday and Wednesday. They had a meeting with the judge Friday morning before court because that's the day they presented it. Okay. It was only verbal at first, and then but Monday had it already signed. I mean, not Monday. Friday they had it signed. Friday morning when they walk into court, they had it signed already. Okay, let's go ahead. Okay, you know what? Let's do this. Do you guys remember what day it was? Do you guys remember what's the day? Is it day 87? That's Friday. What was 80? Was it Friday 87? Day 87? Because I want to play what right before Woody got on the stand. They had 2 meetings on Friday, you said. Okay. Play 87. Okay, let me go get 87. Hold on, guys. Let's get 87. We sitting here trying to be detectives, y'all. Look at us. Look at us trying to be detectives. Hold on. Hold on, y'all. 87, day 87. Okay, let's start. Can we get the likes up, please, guys? All right, here we go. We're trying to be detectives over here, y'all. All right, now, this is Friday's lot. Okay.
Now for all of the extraordinarily important people. Ms. Knight, good morning. All right, Mr. Kokomo, good morning. Ms. Hallwinger, good morning. Mr. Mansbach, good morning. Who? I recognize. Okay. All right. All right, Deputy Avila, all our jurors present, madam?
Yes, Judge.
All right. Before I call for our jurors, any issues I need to take up?
Yes, Your Honor. Your Honor, yesterday evening, the state received a email from John Melnick with Mr. Steele and Mr. Sharp copied on that email.
Listen carefully, y'all. Listen carefully. Listen carefully. So she said they got an email yesterday, which is Thursday, from Melnick, and supposedly Steele and Mr. Shard was CC'd on the email. This is that email, y'all.
Mr. Melnick advised that he represents our next witness in this case. Prior to receiving that email, the state had spoken with our witness on multiple occasions in preparation for trial. After yesterday at about 5 or 6 p.m., whatever time I received the email, he advised that we need to cease all communications with his client.
However, his client is?
Mr. Kenneth Copeland.
Okay.
However, his client is not, there's no open pending litigation. We were operating as a witness. And so Mr. Melnick advised, I don't know if he wants to be present or not, but that he had court at 9 a.m. before Judge Krause. And so I'm bringing that to the court's attention. The state did offer Mr. Copeland use immunity in this case, so that anything that he testifies to in this particular proceeding will not ever be used against him. Your Honor has signed that order, and so we are ready to move forward. However, I did want to bring to the court's attention.
So he's bringing it. She already said the judge already signed it. Did you just hear that? She said the judge has already signed it. According to that, she said they brought it to the judge. He has already signed it. Y'all hear it, right? The judge had already signed it, according to this thing she's bringing up in court.
The time I received the email, he advised that we need to cease all communications with his client.
However, his client is?
Mr. Kenneth Copeland.
Okay.
However, his client is not, there's no open pending litigation. We were operating as a witness. And so Mr. Melnick advised, I don't know if he wants to be present or not,
but that he
No.
had court at 9 a.m. before Judge Krause. And so I'm bringing that to the court's attention. The state did offer Mr. Copeland use immunity in this case, so that anything that he testifies to in this particular proceeding would not ever be used against him. Your Honor has signed that order, and so we are ready to move forward.
The judge
However,
signed the order.
I did want to bring to the court's attention that Mr. Melnick did advise that he was his attorney and that he was present in the building. I believe wanted to.
Okay. Now listen to this, y'all. Melnick reached out to them on Thursday night. The judge signed that order for immunity. So they knew already that he was represented by an attorney, but they did it already. And they just had to put it on record. She was just putting it on record and didn't say that they met with Woody. Yeah, right there. There it is right there, y'all. There it is right there. There it is. So I didn't hear anything about her saying that they contacted you to put a motion in. Oh, this is so wordplay, y'all. This is like so confusing.
To either address the court, but
Okay, well, if he's inserted himself in that particular respect, he needs to probably be here. So can we send somebody up to Judge Krause's to inquire? Because, or is he here? Or is he outside?
I have not seen him yet. So
Is Mr. Copeland or his counsel present?
Mr. Copeland is present in the
Okay.
courthouse. Yes.
All right. Where's Mr.
Judge, I saw Mr. Melnick this morning. I think he's in Judge Carnes' cell.
Oh, maybe it's Carnes.
Okay, can we see if we could find him, please, and have him tell him that we're about to call his client?
I'm not sure if any of Mr. Charlemagne still has. I do not have his phone number.
Okay. Well,
And while we're waiting for that, I do have two other issues.
hold on, Debbie Avila, can you ask one of your colleagues, or Deputy Ham, can you see if you can go up or have one of your colleagues go up to Judge Carnesales and see if we can, one, either get him down here, or two, ask Judge Carnesale when he would be available. And tell him that we also have a witness that we need to call, okay? All right, sir.
And then next, Your Honor, while we're waiting in that pendency, Mr. Copeland does have prior criminal convictions. The state did not see in any.
We might want to take those up if he's got counsel, okay?
Okay, well, I'll wait till.
Yeah, so let's wait till his lawyer is actually here, so we can take up those issues if he does have counsel, okay? All right. I'm just gonna recess in place then. Sir?
Good morning. Can I just step out while we're recessing? Is that okay?
Yes, sir. Sir, do you have any issues of concern or that I need to take up before the state calls your client?
I do, Your Honor.
Okay, go ahead.
May I approach?
You may.
Good morning, Your Honor.
Good morning, sir.
So for the limited purpose of this issue regarding whether Mr. Copeland will testify at this trial, I am representing Mr. Copeland. Your Honor, I spoke with several individuals in the Fulton County District Attorney's Office before this case was indicted. And the Fulton DA's office was very well aware that I was representing Mr. Copeland. Apparently, they have had conversations with Mr. Copeland outside of my knowledge and presence. Now, I can't do anything about that because he talked to them without contacting me first. However, he did contact me yesterday and told me that he was being subpoenaed to testify here today. And I asked him what he wanted to do. His position had been and has always been that he wishes to exercise his Fifth Amendment privilege against self-incrimination. I have explained to him, and I learned this morning that apparently an immunity order has been entered under OCGA 24-5507, granting him use immunity for testimony at this trial. I would object to that proposition. And the reason is this. I know very well that the district attorney's office knew about my involvement in this case from the inception of this case. I spoke with Don Geary in 2021 about this matter. And he asked me whether or not Mr. Copeland intended to cooperate with the state. And what he told me is that Mr. Copeland would probably either be a witness or potentially a defendant in this case. I spoke with Mr. Copeland. We had numerous conversations between myself, Don Geary, and Thomas Greiner, who's in the Fulton County District Attorney's Office, who was prosecuting Mr. Copeland for a separate matter. And Mr. Copeland has steadfastly said that he intends to exercise his Fifth Amendment privilege. I have also participated in a conference call regarding a bond for Mr. Copeland when he was when he had an indictment in Judge Whitaker's division. Present in that conference call was myself, Adrian Love, Adam Abadi, Abby Potter, and Judge Whitaker. And we very specifically discussed.
So Woody has been in front of Judge Whitaker before, y'all. He's been in front of Judge Whitaker before. She's familiar with him.
The state's concerns about Mr. Copeland getting a bond in that case, given that the state wanted to utilize him as a witness in this YSL case. So, Your Honor, Mr. Copeland is here. I can state as his attorney that he intends to exercise his Fifth Amendment privilege against self-incrimination. He does not wish to testify in this trial. And I would ask, there is no other, he's not on bond, he's not on probation, there's nothing like that. I would ask that he be allowed to leave this courtroom without being compelled to testify.
All right. Ms. Hilton, do you wish to respond?
Yes, Your Honor.
All right.
Mhm.
And Mr. Malik, you are correct. I did go ahead and sign this morning. I'll make a part of the record, the court's order. Give.
Oh, he just said he did sign it this morning. So he signed it this morning. It just said he signed it this morning, the order for the immunity.
Giving him use immunity. Okay.
Good morning again, Your Honor. So first, let's give a timeline of events. Mr. Melnick spoke of speaking with Mr. Don Geary. I would believe that.
What does that have to do? Let's cut to the chase. Okay?
So
I mean, all of that, it may be,
So-
maybe historically.
Because I want to make sure the record is clear as to what Mr. Melnick said as far as his representation of him, especially as it relates to him being a witness in this case.
Okay, all right.
So
I'll
Mr.
let you fill in the background.
Sure.
Okay, go ahead.
So when Mr. Melnick, I believe, engaged with Mr. Geary, Mr. Copeland had at that time either two open pending cases, because this would have been in 2020 or 2021. At that point in time, he had open pending charges with the Fulton County District Attorney's Office. Since that time, those cases have been closed, and therefore Mr. Copeland does not have any open pending charges. Therefore, we have not spoken to Mr. Copeland previously when he had open pending cases. We have only spoke to Mr. Copeland as it relates to his being a witness in this trial. Mr. Copeland was subpoenaed a few months ago, but as we were getting closer to his testimony, we resubpoenaed him again last Friday, which was a week from today. When we met with him, we spoke with him briefly. I believe I asked him if he had an attorney or if Mr. Melnick was his attorney. I believe my understanding from Mr. Copeland was that he hadn't spoke to him or that he wasn't his attorney. At that point, we continued to engage in conversation. Mr. Copeland engaged with us. On Monday, we reached out to Mr. Copeland to see if he wanted to come down to do witness prep. We did not meet on Monday. On Tuesday, we thought that he was going to get called. He came down here, we spoke. He asked us questions, we answered his questions, and we've moved forward. At no time during any of those conversations that we had with Mr. Copeland that he advised that he wanted his attorney there. We would have obliged that, but I believe that we were having good conversation as he's a witness in our case. Yesterday at our final prep session, we spoke with him. It was about 1 o'clock in the afternoon in the courthouse. When we left the room that we were meeting in, I saw Mr. Max Shard in the hallway. As we left, we had our greetings. And then it was not until 6 o'clock last night that I received an email from Mr. Melnick, copied Mr. Shard and Mr. Steele on that email, and advised that his client was going to plead the fifth. In the state's conversations with Mr. Copeland, he had some concerns, and we had told him just in general conversation that we would give him use immunity to testify in the trial. Once we received the email from Mr. Melnick last night, we moved forward, Your Honor, drafting a motion in order to give Mr. Copeland use immunity in this case. 24-5-507, Your Honor, lays out that it is the state's purview in order to give use immunity, because it's only the state that brings charges in this case. And we have decided that whatever Mr. Copeland says, he will have immunity in this trial and in this proceeding. And that has been the state's decision, and the state can make that decision. And we have so done that pursuant to 24-5-507. And furthermore, Your Honor, if Mr. Copeland does not testify, he could be held in contempt. We had that conversation with him as well, that he could be held in contempt if he does not testify, Your Honor. And so the state would ask that the order that the court has signed be honored, and that Mr. Copeland be compelled to testify and not insert his Fifth Amendment privilege and testify as a witness in this proceeding.
May I respond, Judge?
Yes, you can, Mr. Miller. So, Mr. Melnick, here's the thing. Your client can certainly advance his Fifth Amendment privilege against self-incrimination. I have signed the order under 24-5-507. So I guess have you explained to your client the potential second and third order effects that could occur depending upon his decision?
I have, Judge.
Okay, all right. I guess the only thing to do at this point in time is to bring him in and determine whether or not he would like to make sure he understands.
I understand.
Where he is under 24-5-507.
He is present in the courtroom, Judge.
Okay.
What he has told me is that he repeatedly told the DA's office that he did not wish to cooperate, did not wish to testify, and wished to exercise his Fifth Amendment privilege. But I can bring him up and have him state that on the record.
Yes.
Okay. Come on up, Mr. Copeland.
Mr. Copeland, come on up and have a seat here, sir. No, he doesn't need to be sworn in yet. No. All right, Mr. Copeland, your counsel, Mr. Melnick, have you had an opportunity to talk with him about testifying today?
Yes.
All right. Has the state provided you a letter of immunity or a copy of the order that I have signed directing that they give you use immunity?
Yes.
Do you have a copy of it?
Yes.
All right. Can we see that, please? Can I need 2 copies of it, actually 3. Not yet, sir.
They still didn't want to give the copy to the defense. Remember they still didn't get a copy because the judge just released it for them to get a copy. Judge Whitaker just released it for them to get a copy. What you gonna get? How long you got? Dallas is about to leave.
Doesn't apply to you yet, Mr. Steele. But it is going to be part of the record, Mr. Steele. I haven't filed it yet under Odyssey. I don't think it's made the Odyssey system quite yet. So anyways.
We have a proposed order.
But I signed the order this morning, though.
I meant, the manner in which will be filed, it will not be made public.
Okay, all right.
Wow.
Which copy's been given to Mr. Copeland? The order pursuant? All right, all right. Do we have extra copies of that? All right, Mr. Copeland, I'm going to mark this as a next court's exhibit in order, okay? Mr. Copeland, can you take a look at that order for me, please, sir? All right, let's just go through it right quick, okay? I just want to make sure that you understand where you are and you have your attorney here. And if you have questions of the court or your counsel, you can go ahead and do that, okay? All right? You have to answer yes or no, sir.
All right.
Okay, all right. I'm not trying to trick you. I'm not trying to do anything other than explain this to you, all right?
Okay.
Okay, all right. Mr. Copeland, this order reads basically, the state of Georgia has moved the court pursuant to this particular statute, which is 24-5-507, to compel your testimony. And our district attorney, Ms. Willis, having determined that your testimony is materially as necessary to the public interest. And that is, and if you take a look at the footnote, sir, I'm sure your attorney's probably explained this to you, that she has the purview of determining whether or not your testimony is needed for a particular trial. I don't even have that authority. Your attorney doesn't have that authority. You can't decide that maybe it's not really necessary. She makes that decision. So, and it's in the public interest. So you've been subpoenaed in this case to appear before and give testimony in this particular matter. And the state has provided the court sufficient reasons as to why you are necessary as a witness in this case. It appears that you've been properly subpoenaed to appear as a witness in this case, and that your testimony is necessary in the public interest. So that's how we, as a due process, gets you to come to court. I mean, you were noticed as a witness. They've identified you as a witness. They've determined that your testimony is needed. Because of the fact that you have some concerns about what your testimony may indicate or could indicate in this case, and that's something that you and your counsel have talked about, and I'm not certainly going to inquire about that. But in order to potentially deal with anything that may come out of that, the state is basically, knowing that you have a Fifth Amendment privilege, says, okay, we acknowledge that. We're going to give you immunity. And as a result of that, then you have to testify as a result of that. If you don't testify, then I, as the judge in this case, have several remedies. One of those is that I could hold you in contempt and jail you because the way that you get out of that contempt is to just testify. That's the only thing they wanted in this case, for you to testify. So your attorneys told me you're going to invoke your Fifth Amendment privilege. Done, said. However, the immunity has been signed. I have a copy of that right now. So you're required to testify. So if you don't testify, the state's probably going to ask me to jail you. And I'm probably going to do that. So I'd like you to go ahead out and talk with your lawyer and tell me what you want to do at that point in time, okay?
Do you need any more time to talk, Mr. Copeland? Okay. What is your desire at this time?
I'm taking the fifth.
Okay, you've taken the fifth, but you've got immunity, but you still want to, are you going to testify? That's the thing.
That's the question.
That's the question on the floor. I've acknowledged the fact you have a Fifth Amendment privilege, but the state's given you immunity, so that overrides that Fifth Amendment privilege. They require you to testify.
Yeah, but the state don't know what they're talking about. So they ask me a question, they implicate me, then.
Okay, they can't prosecute you on that. They can't. The order prohibits them from allowing them to use that testimony against you. That's what your lawyer, and I'm not going to get into any of the machinations or intricacies of what may or may not have happened in this case, but Mr. Melnick is a very seasoned criminal defense attorney. I've seen him over the past 2 decades. I'm sure that he's probably given you very, very good advice, but the state can't use that testimony. They can't kind of say, have it both ways, like you testify and then use that against you to indict you and prosecute you. Then we wouldn't have any faith that we need to have people come in and give testimony. So that's why they can't do that. They kind of can't go back on what they're going to tell you, So I signed the order. Now they've asked for immunity. I've signed the order. So basically, whatever you have to tell us, you tell us.
Say no more.
Do you wish to testify, Mr. Copeland? Is that no? You have to say no on the record.
Say it again.
Do you wish to testify?
He said I can tell him whatever I got to tell him.
That's
So I testify.
You will testify.
Yeah.
All right, sir. Okay. What we're going to do in just a second is I'm going to go ahead and I'm going to call for our jurors. I will formally administer the oath to you, and then the state will ask you some questions, okay? And then you'll be cross-examined at some point in time by potentially
Can I speak to my attorney before? Because I think I just said the wrong thing.
Sure. I'll tell you what, why don't you step outside and talk to Mr. Melnick. Don't go anywhere, okay?
Hold up, y'all. Y'all hear? Y'all listening to this? Okay, so Gunville did the same thing to the defendant before trial started with the plea. Hold on, Kobe. Kobe want me, y'all. Okay, yeah, I'm gonna fast forward a little bit. Let's go over. He's coming back up.
All right, sir. What's your pleasure?
Say what?
I said, what's your pleasure, sir?
You gonna say what?
Do you wish to give testimony? I know you don't want to give testimony in this case, but you've been given immunity in this particular circumstance, use immunity. So are you going to testify?
Yeah.
Okay. All right.
All right.
All right, sir. Then what we'll do at this point in time is we'll call for our jurors and we'll swear you in, and we'll go ahead and take your testimony. Okay.
All right.
All right. What is it, Mr. Steele?
Oh, he sound annoyed still. He sound annoyed. He sounds annoyed.
Does our witness need to be excused? Yeah, sir. Go ahead and stand outside, please, if you wouldn't mind. We'll call you in just a minute.
He sounds annoyed with Steele when he says he wants to say. He said, "What is it, Mr. Steele?" He said, "What is Mr. Steele?"
All right. Mr. Copeland has left us. Yes, sir. What's your pleasure?
Morning, Your Honor. Good morning to everyone. Your Honor, I would like the court to weigh in on this, please. I would like it now. That's why I raised it. But if you do it on a break, that's fine. I mean, whatever you want. But I'm citing to court two cases, if you don't mind. Franklin, which is Franklin, like Donald Franklin Samuel, versus State. It's 166 Georgia Appeal 375. Yes, of course. 166 Georgia Appeal 375. It's in Division 2, 1983. Also Waldrop, which is Waldrip versus Head, like Bubba Head, and that's 279 Georgia. 826, that's Division 2. It's Roman numeral 2A, capital A. 620 Southeast 2D2. Oh, that's wrong. 829 2005. And Your Honor, what I'd like you to do is the state has stated today, and Ms. Hilton told me this last evening. I don't remember the time, but maybe 6 o'clock, 7 o'clock, something like that. We had 2 telephone conversations. She said that she's met with Mr. Copeland and other members of the prosecution team. I asked for any notes that were entitled to exculpatory information under Brady. Ms. Hilton told me that there was one statement, and she emailed that to me and to everyone. But Your Honor, I don't have any of the other notes. Mr. Pland met with law enforcement on the January 11th of 2015. So, God forbid, that's
Brady material they talking
January 10th,
about.
2015, by the early morning hours. I'm going to tell you about 4 in the morning. Mr. Copeland is on video, audio recording with Detective Thorpe the next morning. So it's January 11th, 2015. And he made statements that he knows nothing about anything. Since then, he has made additional at least 5 recorded statements that I'm aware of, and he's made other statements that I have nothing on. Anything that, and he's been inconsistent. So anything that he told the state in this preparation would be inconsistent statements, which is impeachment evidence under Brady. And the state, I presume, will claim work product. That's why Ms. Hilton didn't give us any of the notes. But work product of the state is typically not subject to compelled discovery, except to the extent that such notes may be exculpatory and must be disclosed under Brady versus Maryland, which is 373 U.S. 83. Well, that's under Franklin. And then Waldrop versus Head says that work product doctrine gives way to the accused constitutional right to exculpatory and impeaching evidence under Brady. So what I'm asking this honorable court to do is order the state to produce all notes. They had investigated. If they don't want to do that, I ask the court to get a copy of the notes in camera inspection and then meet with us ex parte so we can tell the court what we believe would be inconsistent statements, which is impeachment. That's why I brought it up to the court.
All right.
Your Honor, as I discussed with Mr. Steele last night, I turned over the statement that I believe was Brady, which was what Mr. Copeland told me about an incident in which there was a theft. And I provided that information to defense counsel. Outside that, the state doesn't have any notes. And so there's nothing else to turn over except for what I did turn over. We do have one additional matter, Your Honor, which would be criminal convictions that I would like to address.
Okay, let's deal with the issue first, the first issue of the notes, okay? Do you have any written notes from your interviews of Mr. Copeland? What Mr. Steele is basically saying is that Mr. Copeland's given a few, he said 5 statements, and that some of those may be inconsistent, which would fall into the category of Brady, or may fall in the category of Brady. So do you have any written notes that you or your team took that arguably would be work product, but that I would need to review to determine whether or not they are on Brady?
We do not have any written notes, Your Honor.
All right, Mr. Steele, then that satisfies that issue in terms of terms of that. If I find out that there's any other additional notes, then I'll change the
All right.
terms of my consideration on that issue.
Okay, I'm gonna end this because I have a mod meeting after at 6 o'clock, and I want to get myself prepared. But guys, I'm gonna come back because there's some more stuff that remember I told you there's some video that I needed to play for you guys with love, and I just want to go ahead and do this meeting and then come back. We do a part 2. Okay, but I got to do this meeting with my folks. All right. So, and there's some bombshell stuff that somebody's been working on and they wanted to share it with you guys. Didn't he sign it at 6 a.m. in the morning? That's what I was told. They said he signed it at 6 a.m. in the morning. What time we be back? Okay. I'm hoping that my meeting won't be no more than an hour and a half. Meeting's at 6. So between 7 and 8, I'll be back. Between 7 and 8, I'll be back. But there's some clippings that I'm going to show you from Love, and something's not fitting right, guys. Something's not fitting right, and we're just going to look at it. All right. So I will be back as soon as we finish with our mods meeting. Mods, though the link to our meeting is in the membership. I mean, in the community. In the community. Let me see. Maybe I'll put it in here. Hold on. Let me put it in here for you guys. Hold on. Hold on a second. Just bear with me a second, and I'll put it in there for y'all. The community wall. All right, I'm gonna put it in the chat right now for y'all. This is for the mods. Okay, just hit that link and come on in to the back. All right, but I'll see you guys at, let's say 8 o'clock, okay? 8 o'clock. I'll see you guys back at 8 o'clock. All right, see you guys. Thank you for being here. Don't forget to hit the like button on your way out if you hadn't had a chance to. And I'll see you guys in a minute at 7:38. No, 8 o'clock. Okay.